name is Johannes Drooghaag, and I once again have a session with my friend Bill Mew. Bill, let's not waste any time. A lot of things happened today, and you have great news. Please, hit me.
Well, there's been some really groundbreaking news in terms of the data relationship between Europe and America. The background here is the fact that Europe has always had an orientation around privacy, and we see privacy as a human right. The attitude in America is very different. They tend to have a far greater priority around national security, and with it comes a lot of mass surveillance. Going back a number of years, we struck up an agreement for data sharing with the US, where we opened up our data to be shared with them on a far greater basis than is shared with any other nations around the world. Typically, these type of data sharing agreements are part of any sort of trade negotiation, because when you have a trade agreement, you need to set up an agreement, an arrangement where goods move in one direction, payment moves in the other direction, and data moves in both directions. But the provisions that we specifically were concerned around were the sharing of personal data. This has come to a head recently. Indeed, it came to a head a short while ago because the earlier arrangement that we had in data sharing between Europe and America, which was called Safe Harbor, was overruled because Safe Harbor was found not to have sufficient adequacy in terms of the amount of protection that was being afforded to our personal data when it went to America. Mm-hmm. So the two political establishments on both sides of the Atlantic moved very quickly and hurriedly put together a new agreement called Privacy Shield. Now, Privacy Shield in reality isn't a great deal different from what had gone before it. It was a bit like putting lipstick on a pig. It was still a pig. And therefore, what we've been facing is a massive mismatch between these two big trading blocks in what their expectations were, not only around privacy, but around mass data surveillance. Gradually, the ground has been moving beneath our feet because in Europe, we've actually reinforced our privacy protections over recent years, largely with the introduction of GDPR, which I think is possibly now the gold standard worldwide and is being copied by many other countries in terms of privacy protections. Meanwhile, in the US, they've been moving in the opposite direction, introducing a number of different erosions in the level of privacy protections that they provide. We saw the Edward Snowden revelations around the PRISM program of mass surveillance, which was shocking enough. They also in the US have Fisa Warrants, which is a US surveillance program, which is overseen by secret courts that issue secret warrants for getting a hold of people's data. They do have a Privacy Act in the US, but the current president, in his first week in office, signed into law an executive order that the Privacy Act in the US applied only to US citizens and not to citizens of any other nation. This included the EU, it included Canada, it included all the other nations. And that further undermined the amount of privacy that we had. Mm-hmm. We then had the Cloud Act. Now, the Cloud Act was an extraterritorial measure that forced US-based technology companies via a subpoena or a legal measure to produce data that was stored on their servers, irrespective of where those servers were located, be it in the US or abroad, including Europe. And this meant that the large technology players in the US, like Amazon or Microsoft or Google or Facebook, even if they were storing data in Europe, because they were based in the US, they were subject to the Cloud Act. And this extraterritorial measure that the US had introduced meant that data wasn't safe from the NSA, the CIA, and others. if you were using one of those major US cloud providers.
Mm-hmm.
Finally, we've got a couple more. The Earn It Act, which has gone even further, and this created a 15-member government commission to bring forward best practices for the detection and reporting of child exploitation materials. Now, this had a very worthy goal, but actually the way it went around it and the measure that it was suggesting of bringing forward, including things like introducing backdoors into encryption and dismantling the Section 230 protections, all of which would have very significant negative consequences. And finally, just to put the icing on the cake, we have the most recent piece of legislation, the Lawful Access to Encrypted Data Act, which is not yet law. It's been introduced to the Senate, and it may or may not be actually put into law, but it would be an enormously serious measure that would end any kind of end-to-end encryption services being offered online. It would prevent companies from offering encrypted devices like the protections you get on iPhones, that they would have to be have a way for law enforcement authorities to unlock them, and it would also prevent any form of other encryption being provided where there weren't backdoors specifically for US law enforcement. Now, all of this would be with the keys for this encryption, the keys to these backdoors being held not by a neutral party like the UN, but by the US themselves and the NSA and the CIA and the parties that have been already participating in the sorts of mass surveillance that we've seen with the PRISM program. So all of these measures have gradually eroded the protections that have been in place at a time when Europe has been moving the other direction with GDPR. And this was a mismatch that was crying out in plain sight. But the politicians in their annual review of Privacy Shield each year had backed away from actually taking any action.
Well, that's a long line of information leading up to the status where we are today, Bill.
Well, the action that's been taken today has a few impacts. Basically, Privacy Shield has been ruled as inapplicable, so it has been totally negated. But it doesn't mean that all data sharing needs to stop straight away. For starters, Privacy Shield only applied to the sort of private data that we share. And also there are other mechanisms for sharing data. We have standard contractual clauses. Now, Privacy Shield and Safe Harbor before it were very broad measures that applied for each trading block. Standard contractual clauses would be applied individually to each different company that was going to be sharing data. So it means that there's still another approach that can be taken. But standard contractual clauses still need to recognize the need for privacy and protection from mass surveillance. And therefore, there are some companies that would be prevented from using standard contractual clauses and for whom there is now no mechanism legally for taking data offshore. We need to think about this in terms of the types of data we're talking about here. So if there is a company that has got production data or financial data that it's reporting in one direction or the other, there's no problem with that because that's not private data. Where there is private data, we do have an issue, but there are also times when there is a real need to share a level of private data. So if you're in the US and I'm sending you an email, I need to include my name and my email address and certain details, or you won't know who it's come from and you won't be able to reply. Also, I need to obviously include details of the recipient or it won't get there. There are other very obvious needs to share data. Let's say I'm booking a hotel in America. I need to include my name and details so that people know who's booked the room in the hotel, and it needs to be sent to America so that they can make that reservation for me. So obviously, where there is a real need for personal data to be shared, that needs to be still allowed to happen. But if I am sharing photographs with a small private group on Facebook, or if I am messaging someone here in the UK or in Europe, is there any real need for that photo, that message, or any of that data, personal data, to go offshore to America? No, there is no need whatsoever. And therefore, the ruling today is that we have to focus on looking at the real needs to take data offshore. Also, standard contractual clauses can protect you from any intrusion based on a promise that the organization has made to protect that data. But there are certain organizations that can't make that promise, because some of the privacy erosions I've talked to you earlier, one of them was called Fisa, which is the the secret courts with the secret warrants where they seize data. This applies to electronic communication service providers. And so that's all of the telecommunications companies that are based in the US, all the social media companies that are based in the US, all the cloud firms that are based in the US, everyone from Apple to Google to Facebook to Twitter to WhatsApp to AWS to Azure to all of those organizations. All of those are subject to Fisa warrants. And therefore, the very fact that these companies could have that data seized by the authorities in the US means that the company signing a standard contractual clause promising to look after your data is not providing a genuine promise that it can keep.
Exactly.
And therefore, what we're seeing based on today's ruling is Privacy Shield is dead. Standard contractual clauses can still be used, but not by any of those large service providers that I've talked about. And also importantly, not by any companies that are transferring data offshore and storing it with one of those companies. So if I am a company that is a multinational that is collecting private data about my customers, I need to be thinking very carefully, do I need to take any of this data offshore? Do I need to take it out of the UK? And the question, or the EU, and the question to, and the answer to that is normally no. There's normally not a necessary need to do that, unless we're doing things like the email or the hotel bookings or something that are genuine need cases that I gave examples of before. They also need to be thinking of, if I do need to take information offshore, who am I going to store it with? If I'm going to have standard contractual clauses in place, and I store it in my own servers, in my own data center, then actually I can genuinely protect that from the type of intrusion and mass surveillance that we're talking about here. But if I am Netflix, who has most of their data in the cloud with one of the big service providers, if I'm another company that is a big client of AWS or Google or Azure, then I cannot make that promise. I cannot sign a standard contractual clause and make a promise to people that I'm going to protect that data, because I'm unable to, because the people I'm using to host that data are subject to these type of secret courts, these type of secret warrants where that data can be seized, and I can't stop it.
Exactly.
So that is going to lead to a massive change. So what we're going to see in the short term as a direct result of this is the fact that companies are going to need to reconsider the protections that they have in place. They're going to need to reconsider what data they're moving and where they're storing it and who they're storing it with. And there has been a massive a challenge here to the US surveillance program. Now, the US needs to take a very serious think about whether it's going to continue with this level of intrusive mass surveillance, or whether it's going to actually show a level of respect to US citizens and their privacy rights in the same way as it would demand for its own citizens. I mean, if the boot was on the other foot here and we had agreed an arrangement with the US where we promised a level of equivalence, and then, as Trump did, we suddenly enacted a local provision that said, actually, the privacy that we promised to all the US citizens, that doesn't apply anymore. It's only for us here in the EU. The Americans would be hopping mad if we treated them like that. And yet they expect the Europeans not to complain when they do exactly the same thing. And therefore, the Americans need to think very carefully about reforming their mass surveillance programs and where they're going to take that if they want to protect the financial viability of a lot of the big technology companies that they're seeking to champion, from AWS and Google and Azure in the cloud space, to the telcos and to the social media platforms, all of which have effectively been undermined by the needless intrusion that the US has done into our privacy here in Europe.
Exactly, Bill. And now that you mention Europe, January 1st is coming up fast. We know that all. And this is mainly a ruling on the relationship when it comes to privacy and when it comes to data management between the United States and the European Union. Now, as of January 1st, the United Kingdom will formally, in no form whatsoever, be part of that European Union. What does this mean for the privacy for citizens of the United Kingdom?
Okay, when we do any kind of trade agreements, obviously we have to put a whole lot of provisions in place. There will be standards that we apply for the goods that we trade in one direction. There will be standards that we apply for the financial compensation we do in the other, anti-money laundering, things like that. But there will also be standards that apply for the communication that goes in both directions. The UK, whilst it was a member of the Club of Nations within the EU, was looked on with a very sympathetic manner. And despite the fact that we had enacted into law a law here in the UK called the Investigative Powers Act, also nicknamed the Snoopers Charter, that was to a large extent overlooked by our European peers because they wanted to have an inclusive arrangement for all the European member states. Now that we're being looked at as a third party, an organisation outside the EU, we are being reviewed with a completely different perspective. And the UK is in a position where unless we do away with the Investigative Powers Act, or unless we put in place special protections and provisions for European citizens, much as we're asking the US to do, then there will be possibly a ruling that the UK fails in its equivalence in terms of GDPR. We will end up having a European GDPR that has one look and feel, and a UK GDPR that has a slightly different look and feel. And we won't be able to guarantee equivalence between the two. And that will cause problems in terms of data sharing between the UK and EU post-Brexit. And therefore, we'll have not only a problem in data transfers across the Atlantic, we'll have problems across the Channel as well.
I think so too, Bill, and I think that this is one of the many challenges that the UK has to face, because there is basically no business without data, right? And there is basically no data without business, but that is a different topic. I think it's crucial that all partners involved take this as a high priority. I do not see that in the protocols about the negotiations. That worries me a little bit, but I
think people are aware of it. Unfortunately, there is so much to be agreed, and there's so little agreement at the moment that I fear it will be left to the last minute.
I
but
feel
one
too
other thing one other thing I need to come back to around the big decision in the court today, they not only ruled on some of the data sharing between Europe and America, they also made a ruling about enforcement here in Europe. And this is important because up until now, just as each time we did a review of Privacy Shield, the politicians were very reluctant to rock the boat. They expressed their discomfort at some of the measures that the Americans had taken, but they were reluctant to overturn the agreement, and therefore it's taken a legal challenge in the courts to make that happen. In the same way, the regulators that exist in all the different countries have been reluctant to push ahead with enforcement against big, powerful global organizations. And we have a data protection authority in all the different countries across Europe. The one that is possibly most significant here is the Irish one, the Data Protection Commissioner in Ireland, because many of the large technology companies like Facebook and Google and Microsoft and others all have their European headquarters in Ireland, and therefore it falls to the Irish authorities to do enforcement of GDPR within Europe when it comes to many of these large companies. Now, we're all very well aware of some of the repeated abuses that we've seen by Facebook and some abuses by some of the others, and therefore the Irish data regulator has accumulated a massive backlog of really big cases against some of these technology giants. And the Irish, because they have a favorable tax regime and a very favorable environment towards these technology giants, don't really want to rock the boat either. But again, this court hearing has actually forced their hand. It has come out and said that the regulator has an obligation, it has a duty to bring forward enforcement in a timely manner. And this is not only a bit of a kick up the backside for the Americans for their mass surveillance, it's a bit of a kick up on the backside for the Irish regulator in dragging its heels and not necessarily bringing about timely and adequate enforcement.
So it's definitely not the end of the game with this one, Bill, but I think there are two very important steps forwards. One is that we finally cut the ties with Privacy Shield. And the second one is that we finally identify that every DPA has the obligation to act when there is a breach or an abuse.
Arrangements and sort of laws like GDPR are meaningless without enforcement. And therefore, we need to have, first of all, a level of recognition of GDPR in our data sharing arrangements with America. They can't just ignore it and have repeated abuses of our privacy. And we need enforcement here in Europe by the regulators such as the one in Ireland to make the regulations meaningful.
Exactly. Bill, thank you so much for these insights. Thank you for your opinions. And thank you most of all that you made the outcome of this ruling understandable for all of us.
I look forward to our next discussion, and hopefully we can shine some light on some other interesting topics in the future.
That's just about what I wanted to say. I can't wait for the next thing so you and I can sit down again and have a good talk about it. Bill, thank you very much. Talk to you soon. And I'm sure enough will happen for us to have conversations.